case briefs, and so much more. LSData's got what you're looking for.
In a tense legal contest between RBS Citizens and Jan Ouhrabka, the central issue revolved around the question: can a creditor attach the property jointly owned by a debtor and a non-debtor in a tenancy by entirety to repay a debt? The issue originated from a loan agreement. RBS lent funds to Ouhrabka, requiring him to sign a personal guarantee for loan repayment. When Ouhrabka defaulted, RBS pursued Ouhrabka's Vermont property, jointly held with his wife as tenants by entirety, to settle the debt. The RBS maintained that the notion of tenancy by entirety was archaic and in need of replacement, asserting that a creditor should be able to attach this form of jointly owned property. However, the court held a different view and rejected RBS's motion to attach the Ouhrabka's property. In the final ruling, the court pointed to Vermont's endowment of extensive protections to tenancy by entirety, specifically the Rights of Married Women Act. Owing to these protections, the court ruled against RBS and declared that it could not attach property jointly owned under tenancy by entirety for individual spouses' debt. The court drove home the argument that Vermont law makes no distinction between voluntary and involuntary property transfers. RBS, the court elaborated, had alternative recourse to handle Ouhrabka's default, including a fraud action or compelling both Ouhrabkas to shoulder the debt. As they failed to take these steps, the court affirmed that they would not adjust existing entireties law to accommodate RBS's oversights. This landmark verdict underscored the robust protections Vermont law accords to marital property, forcing creditors to rethink their strategies.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.